So I have some really bad news for all of you, and it has to do with the Fourth Circuit Court of Appeals and them essentially cheating so that they can protect a state's ban on so-called assault weapons. And this is all happening in a case which was granted, vacated, and remanded by the US Supreme Court after they issued their Bruin decision. But once again, we've seen a Circuit Court of Appeals decide that they are not going to play by the rules and they are going to directly defy the Supreme Court. So let's talk about what is happening. But really quick before we jump into this video, if you agree that these types of bans on so-called assault weapons, essentially just rifle bans, should be struck down and are unconstitutional, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit them using the links down below. And thank you again to SDI for sponsoring this video. So as I mentioned in the intro, I have some unfortunate news for you that we have to talk about, and it has to do with the Fourth Circuit Court of Appeals recently deciding to take the Maryland assault weapon ban case Bianchi v. Frosch, or now the Bianchi v. Brown case. They have decided to take it en banc. Now, when you hear that, you may be thinking to yourself, well, that doesn't sound so bad. You know, isn't it a good thing usually when cases go en banc and when they're elevated to the next level? You know, maybe is this a good thing? Well, it's not. What is happening here is that the Fourth Circuit Court of Appeals has decided once again to go rogue and do everything in their power to not only avoid a pro 2A decision, and they don't want one to be issued by that 3-judge panel that has already heard this case, but also they're almost telling the US Supreme Court that they will not follow Bruin, they will not follow their orders, and they're almost daring the Supreme Court to do something about it. Instead, what the Fourth Circuit has now clearly shown is that they're going to do everything in their power to protect these bans on so-called assault weapons. We've been waiting for over a year now for this decision in this Maryland Bianchi assault weapon ban case. You know, oral arguments in this case happened back in December of 2022 after the Supreme Court issued their Bruin decision and then actually granted, vacated, and remanded this case Bianchi back down to the Fourth Circuit for them to reevaluate this case, reanalyze this case in light of Bruin. Now, of course, we've covered the Bianchi case in the past. We've done videos. We did videos after those oral arguments back in December of 2022. And my impression and a lot of people's impression after those oral arguments was that we were probably going to get a pro 2A decision. It was likely going to be at the very least a 2-1 decision, which struck down this ban on assault weapons in Maryland. But then this case sat silent for about 13 months. And then we received an order out of the blue from the Fourth Circuit that they have now decided that they want to take this case en banc after 13 months, and they will not allow that 3-judge panel to issue their decision, which most likely was going to be a pro 2A win. Think of this like what just recently happened in the Ninth Circuit Court of Appeals with the Duncan v. Bonta magazine ban case. In Duncan, the Ninth Circuit en banc panel took the case away from the lower court there. They didn't allow a motions panel to review the stay. They didn't allow a 3-judge panel to review the magazine ban decision by Judge Benitez. Instead, they decided to avoid a 3-judge panel altogether and decided to take the case en banc as a comeback case. Similar to what is now happening in the Fourth Circuit, the Fourth Circuit is going to do something very similar. They're using some of their internal rules essentially to protect this ban on so-called assault weapons. They don't want a pro 2A decision, so they're going to take control of the case and then likely sit on it for as long as possible. Now, for those not familiar with what's going on with this specific challenge, let me break down some of the quick background of this case. The state of Maryland identifies certain rifles as so-called assault weapons. Not my term, it's just simply what they define it to be legally. Maryland bans the sale, transfer, and possession of semi-automatic centerfire rifles with detachable magazines and 2 offending features like a folding stock, a grenade launcher, or a flash suppressor. It also has some other bans like bans on semi-automatic centerfire rifles that have fixed magazines but can accept more than 10 rounds. The state also has a specific list of makes and models, I believe 45 named types of rifles that they ban as so-called assault weapons. This structure is kind of similar to what California has, but there are some workarounds, I believe, in Maryland with their heavy barrel rifle rules. So there are some ways to get around it. But currently, that is the law they have in Maryland. That's the assault weapon ban, and that is what's being challenged. This ban was originally challenged in a Maryland district court, and in the original complaint, the plaintiffs had to concede that their Second Amendment claims were kind of foreclosed at that district court level based on a prior Fourth Circuit decision on this very issue. A prior case called Colby did in fact challenge Maryland's assault weapons ban, and in that Colby case, a district court upheld the Maryland ban using intermediate scrutiny. And on review, a divided panel in the Fourth Circuit concluded that these rifles are protected by the Second Amendment and that the ban substantially burdened the right to self-defense within the home. And on that basis, what ended up happening in Colby is that the three-judge panel struck down that ban using strict scrutiny. Well, of course, the state of Maryland didn't like that. They weren't going to let that Colby Pro 2A decision sit back in the day, so they sought en banc rehearing once again in the Fourth Circuit. And on review, the Fourth Circuit en banc panel upheld the state's ban, finding that these rifles are outside the protection of the Second Amendment because what they claimed, they are useful in military service. So that case, that prior decision in Colby, currently stands as precedent in the Fourth Circuit. This case, Bianchi, conceded that Colby is the controlling precedent in the Fourth Circuit, but that it's incorrect and should be reversed. The district court in this case, Bianchi, ultimately dismissed the complaint for a failure to state a claim because of that prior Colby decision, and that dismissal was then appealed up to the Fourth Circuit, and the Fourth Circuit once again upheld the dismissal, saying, hey, you can't bring this challenge because of Colby and our prior precedent. But then this case ended up getting appealed up to the U.S. Supreme Court, and it sat at the Supreme Court level in 2022, seeking review on this issue. But in 2022, as we all remember, the Supreme Court ultimately ruled in a landmark Second Amendment case, New York State Rifle and Pistol Association versus Bruin. Now, after issuing that 6-3 decision in Bruin, the Supreme Court issued a GVR in this Bianchi case. That means that they granted review, vacated the judgment down below, and then remanded the case for reconsideration in the Fourth Circuit. That reconsideration requires that this case be reheard using the text as informed by history and tradition standard of review. This case was then opened back up in the Fourth Circuit Court of Appeals level, and a three-judge panel held oral arguments back in 2022, I believe in December of 2022. And so the three judges there seemed to be very favorable. The three judges were Niemeyer, Thacker, and Richardson. From listening to the oral arguments myself, back in 2022, we listened to them. We've done some videos in the past. It seemed like it was going to be a pretty good, 2A decision. At least it was going to be a 2-1, decision in our favor. But then, as I mentioned, this case sat pretty much silent for 13 months. And then we received this order from the Fourth Circuit. It simply states that a majority of the judges in regular active service and not disqualified having voted in a requested poll of the court to grant rehearing en banc, it is so ordered. That rehearing en banc is granted. The parties and amicus curiae shall file 16 additional paper copies of their briefs and appendices previously filed in this case within 10 days. The case is tentatively calendared for oral arguments during the next available argument session. So what does this mean? Well, first, there's not going to be any decision by the three-judge panel, which was likely going to be pro 2A and probably strike down this ban using Heller and Bruin. We've been waiting for that decision for 13 months, and we're likely waiting because the en banc panel was preventing it from happening probably, and we're just not going to get that decision. Also, neither the plaintiffs nor the defendants were the ones that called for en banc review. Instead, it was an internal mechanism of the Fourth Circuit, which was asking for a poll of the judges. Someone did that. We don't know who it is. And the en banc poll happened, and that liberal Fourth Circuit decided to take this case away from the lower court and take control of this case to issue a potential decision. It could have been that they saw the pro 2A decision that was probably being written or, was going to happen by the three-judge panel. And they said, well, we're not going to let that happen. So, let's take control of this case and, pretty much just prevent that from happening. Ultimately, I believe this is just not a good thing. The Fourth Circuit is likely going to try to sit on this case for as long as possible. They're going to try to stall this case, as much as they can. Right now, the oral arguments are tentatively set to happen, I believe, during the week of March 19th through the 22nd of this year. However, briefing and argument schedules are oftentimes changed and pushed out, and nothing right now is really preventing the Fourth Circuit from doing that. And then also keep in mind that even after the Fourth Circuit hears this case, after the en banc panel hears, oral arguments, they could sit on a decision for another 13 plus months. They could sit on this for as long as they want. They could just simply not issue a decision for as long as they want. What this really signals is that judges in these liberal circuit courts are going to do everything within their power to avoid any pro 2A decisions, from being issued by lower courts, by three-judge panels. They're going to try to do whatever they can, sometimes even break their rules like out in the Ninth Circuit or use some of their internal rules to take control of these cases and sit on them or avoid pro 2A decisions. Unfortunately, the Supreme Court's inactivity in these cases is also allowing the lower courts to do this. And a lot of them, a lot of these circuit courts are pretty much hoping that after the election, maybe they can replace some of these justices like Thomas or Alito if they decide to step down or something happens. They're hoping that they can replace them, or maybe they're just waiting to pack the court. So really not good news right now out of the Fourth Circuit. So if we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.